complaint. It doesn't mean a civil complaint. It doesn't mean a criminal complaint. So in this instance, if she was in Pennsylvania, I could do a precipice to the notary, to the profanatory, telling her, serve them that rule. And what that rule tells them is they've got to sue me within 20 days. Guess what? They're never, ever, ever going to sue me. You know why they're not going to sue me? Because they have no cause of action to file against me for not following their ordinances or their resolutions. They have no cause of action to impose upon me to follow their ordinances or resolutions, because the only possible way they get me in a civil action would be a contract breach. I don't have any contracts or performance contracts with these people, so they can't bring a breach of contract action against me. So what the heck cause of action could they possibly file for me not following their ordinances or resolutions? How about zero? Nothing?
Yeah.
Okay.
Well, hold on. Well, let's just put it in the perspective. Okay, so this phony baloney law firm bringing an action for the fictitious plaintiff, okay, writes this single sheet of paper stating that you don't get to, they don't have to substantiate the claim. They just make it. They put a
say?
Yeah. Hey, there's no cause of action. There's nothing in there that you're defending. There's nothing. Now, if I was to go do that, what would that be? Failure to state a claim in which the court can grant relief. Get out of here.
Brandon, let's touch upon this. Let's relate it directly to people, their understanding. When you say you get a code idiot writes you a citation because you didn't get a permit to put a roof on your house, okay? And he writes you this little fine, whatever. Here's what happens. They'll give it to their law firm, or the code guy will file it. They'll file it with the profanatory, which is basically the clerk of the court, okay, your municipal court. Guess what? The clerk of the court, she don't work for the court. She's a county employee, okay? I was stunned when I found that out. I thought she was a court employee. They said, oh, no, she don't work for us. She works for the county. So here's what happens. The lawyer creates a phony lien against you, a claim or a lien. It's called a claim. He'll start it. When he files it with the profanatory, she's just a glorified secretary. She's a clerk. She gets it. She turns it into a judgment against you and converts that judgment into a lien. Was there any due process in this matter? Were you ever notified beforehand to defend against this? No. There goes your due process right out the window, okay? Was there any service of process in this matter? No. Service process means, like Brandon's talking about, a process server knocks on your door and says, Mr. Sibley, you've been served, okay? You're being sued. They send you something in the mail. That's not process of service. I don't care what they say. That's not process of service. There's a reason we pay process servers $150 to serve documents, because it's how we initiate court cases. Otherwise, I could slap a 50-cent stamp on there and start a court case by just dropping it in the mail. They're not going to let me do that. I can't start a court case by dropping a letter in the mail, and neither can they. Neither can your township, your borough, or your county start a case like that.
And so that's how you know how illegal the IRS is too, by the way, because they send things by regular mail to old addresses so they can go to their administrative freaking tax court and go get a judgment against somebody. Make no mistake, folks, U.S. tax court is completely administrative. It is not a real court. It is an administrative functional court. And so they send things by U.S. mail, hoping that nobody gets it, and they just go get a notice of deficiency turned into a default judgment. And most people get their eyes batted out their head because their bank accounts are seized. And it's all by fraud. It's fraud.
No. And here's how corrupt these local courts are. I served this rule upon the township where I live. I sent it to the clerk back in back in October. I sent it to her, okay? Back in October of last year, I sent it to her. She would not issue the rule. It's plain as day. You could read it. There's no ambiguity in that rule. She would not issue the rule. You know why she wouldn't issue the rule? Because I just blew up the entire tax system in Pennsylvania, the local tax system. Because anytime somebody comes at you, you could serve this rule upon them, and they could never sue you for not paying taxes. Not going to happen, okay? So she wouldn't do that. So I had to push to get a hearing. And Brandon heard the audio, the hearing. The judge, now get this. We know that clerks can't issue judgments. Clerks are not courts of judicial, they're not judges, okay? They're not courts of competent jurisdiction, a clerk. They can't issue judgments against people. That'd be a violation of what, Brandon? Due process, and a violation of your right to trial by jury. So the clerk can't issue judgments against you, but she will. So I'm in this court process, and the judge says, well, he's trying to give me, he said, well, let me give you a roadmap on how to fix this. He said, listen, file a precipice to open the judgment. I said, no, there is no judgment. Why would I file? It's called a precipice to reopen the case, or reopen the judgment. Why would I file a precipice, a petition to reopen a judgment that doesn't exist? We know the clerk can't issue the judgment. Why on earth would I file a petition to reopen a judgment that doesn't? No, here's my standing. Listen, when push comes to shove and I take it to the federal district court, there ain't no way anybody's coming in and saying that clerk entered a judgment, because clerks don't issue judgments. And there's no way they're going to answer that in a legal pleading that clerk issued a judgment, because it's so against the Constitution. You couldn't get any further away from the Constitution. So that's not going to happen. The corrupt judge was trying to tell me that my remedy was to file a petition to reopen a judgment that never existed. I said, no. There is no judgment. That rule upon them and let them sue me within 20 days, or I make this all go bye-bye. So this is what's going on with your court systems, your local court systems.
Yes, and so I'll read this. So guys, listen, when I found this, the light went off for me, and I'll just tell this story to y'all. I don't think I've told it yet, but so I had an issue with a family member deciding to call the Wildlife and Fisheries on me, and Wildlife and Fisheries executed a warrantless search and seizure of property that was exclusive to me. So I called up each of the agents, started doing my own investigation, got all the details out of all of them, and that's how it works, folks. Got all the details out of them, called the Secretary of Wildlife and Fisheries, put in a records request, notified the Secretary, said, oh, by the way, your agents conducted a warrantless search and seizure without affidavit of probable cause of any criminal activity being committed. And here was the funny thing, because as this is going down, I'm researching the offenses and the citations of the Wildlife and Fisheries, and I come upon reading all the. Here's the key, folks. Just don't say something. Go read the statutes. Go read their authorities. Actually go pull it up and find the limitations of their authorities, and you're going to be pretty surprised that it's been there the whole time. Yes, we have been dumbed down. We don't know our substantive rights. We don't know what due process is. We think the local kangaroo court judge up here actually has the authority to do what he's doing. But no, it's turned into a business model, okay? Everything's a business, okay? But the truth is that when I went and read the Louisiana Administrative Procedure Act, it read as dust. I told you it was Article 49. The Louisiana Administrative Procedure Act is the law. Hold on. Let me go back to that. Wildlife and Fisheries can change their code anytime they want. The Transportation Code can change anytime they want. The law governing the administrative policies that can't change, okay, is the Administrative Procedure Act. For state administrative agencies to propose and issue regulation, and provides for judicial review of agency adjudications and other final decisions in Louisiana. So what each of you can go do is pull up your own Administrative Procedure Act. It's going to be so the rules of civil procedure of Louisiana, the rules of evidence of Louisiana for normal operating courts are explicit. But for the administrative courts, where are they? They're in the statutes. And so when I started going to read the statutes, we'll go back. And we'll start flipping through here. I've got a few things just to itemize for y'all guys. I don't just do this for nothing. But we'll go. There's one place I got highlighted that I want to show you. I'll get to it. Just give me a second. I can't remember which one it was. I highlighted it. Well, I guess I lost it. Whatever. But anyway, inside here, it actually tells you, see the judicial rules and everything else here. You start getting into the actual quasi-judicial rules of the courts and all that stuff. Oh, here it is. The court may affirm the decision of the agency or remand the case for further proceedings. The court may reverse or modify the decision if substantial rights of the appellant have been prejudiced because the administrative findings, inferences, conclusions, or decisions are what? What's the supreme law of the land? in violation of constitutional statutory provisions in excess of the statutory authority of the agency, made upon unlawful procedure affected by other error of law, arbitrary or capricious, or characterized by abuse of discretion. So let's go back to this thought process here. The Louisiana Constitution enumerates in Section 27 of the Louisiana Constitution that all men have the freedom to hunt, fish, and trap all aquatic life. Can there be a restriction of that? No. It states all men. So where does the restriction come from? The regulation comes from the administrative side. It has to come from agencies or instrumentalities or businesses, people out there trying to sell. There's good reasons for this. You don't want somebody out there fishing and selling, let's say, blue marlin, but he's really catching mullet.
Right.
Okay. There's good
these agencies have their purpose. They're actually put there to actually make it easier to govern things. Okay. But what's happened is the people that are working there have no understanding of law and no understanding of their limitations. And they're just imposing it upon everyone when it's not meant to do that.
Yes, and that's the truth. I am not anti-government in any kind of way. I'm not. But what we have is a completely dumbed down society. And listen, Gary went back to the courthouse today. Okay, we have an injunctive relief that we're writing. And we're almost finished with it against the United States Marshals. He went up there again today, one last time. By the way, the Louisiana Supreme Court ruled 3 weeks ago that the mask mandate is unconstitutional. Okay? Now, guys, that ruling applies to who? Everybody. That's the full faith and credit clause of the United States Constitution. Okay? How many people did they publicize that ruling by the Louisiana Supreme Court? Here it is. Here. Let's just do it for everybody so they see it. I don't know how many people actually know this. This is the Supreme Court of Louisiana on the 13th day of May 2022. And this was a granting of a motion to quash. And they called John Bel Edwards, the governor of Louisiana, his mask mandate unconstitutional. Now, you can incorporate this in any pleading that you have on any mask mandates or anything else because they're all unconstitutional because they violate the rights of property, the rights of privacy, and the rights of freedom of conscience. That's just simple. We had a great ruling right here. Let's see if I can. I'll upload these documents to Telegram, but Telegram's already got them. We're already discussing these ideas. We have great, wonderful people ruling perfectly right now. We've got our opportunity to get in these courts and really cause some good damage, box people in their ears a little bit, and wake the masses up who are just fast asleep at the wheel. Look, there's only one way men of less intelligence learn, folks, and that's by experience. They're not going to learn until something kicks them in the ass. I'm sorry. That's just the way it is. Go ahead, Alphonse.
No, listen, there's people say, well, codes and statutes don't apply to men and women. Listen, it depends on what the code and statute is. Like Brandon said, the criminal statutes and codes, they're going to apply to you, okay? If you murder somebody, guess what? You're a person, okay? You're not going to get away. It depends on the, like he read the statutory construction. It depends on the context in which it's taken, okay? If you're talking about tax code and you're talking about corporations, no, that doesn't apply to me in that context. But if we're talking about criminal law things, about stealing or assaulting somebody, yes, the statutes and the codes are going to apply to you. So don't just go with that stupid thing and just say statutes and codes don't apply to men and women. Depends on the context of the statute and code. Everything's unique and separate. You have to look at the context of what they're claiming against you and then attack it from there. But you're just not going to go in there with a citing and say, hey, listen, if you put that in your paperwork, hey, listen, statute and codes don't apply to men and women, they're going to write you off, okay? Now that's your opinion. You're not going to find any Amjor cases where they're going to say statutes and codes don't apply to men and women. No, you've got to deal with that particular code or statute and in the context of how they're trying to relate it to you and what the charges are. Then you can attack it and prove that this particular code or statute doesn't apply to me, and here's why. That's different than just saying this all they don't apply. Come on.
Well, and when I talked to the Secretary for Wildlife and Fisheries, I said, hey, listen, I understand the limitation of your authority is outlined in the Administrative Procedure Act, and you don't have any business going on my private property when clearly all the signs up on the building said no trespassing. That means you look, you can't. In order for them to get on that vessel, they had to have a warrant, an affidavit of probable cause of a crime being committed, and none of those elements exist for that to happen. Okay. None of those elements exist. So what they did was do a warrantless search and seizure. So I've got another lawsuit coming up. And this is the beauty of this. When you do finally put all this together, I think Steve Emerson says this too. You never run out of idiots to sue.
Target-rich environment. Okay. Yeah. Here's the hardest part for me. Trying to decide which one to finish first, which to hit, because they're coming at you so quick. You're like, I can move this, I can move that, and I can move that. So you start moving one thing, and then something else happens. You go, oh, let me address this. You got to like set it up in a list. I'm hitting this first. I'm hitting this next. I'm hitting this next. Okay. You're never going to be sitting there going like this, twiddling your thumbs, going, gee, I don't have anybody to sue. You'll have lawsuits till you're 90 years old if you want to file. There's always going to be stuff. Once you understand the rules, you're going to understand how outside the rules these people actually are operating. And listen, there's nothing like looking at an attorney and telling them, hey, sir, you committed forgery by filing that lien against my property. That's securities fraud. You have no authority whatsoever to file liens against property you don't own and you have no interest in. And you should see the look on their face when they see someone confront them with that. Because here's how this works. When I sue Mr. Attorney in federal district court, he cannot come into court and say, hey, this statute gave me authority to do this to Mr. Fagiola. That's not going to happen, okay? So when you learn these rules and learn these procedures, and Brandon's going to touch on it probably coming up, take that jurisdictionary course. It's the best $250 you're ever going to spend, because you're going to learn how the process works, and you're going to learn what the paperwork is and how courts have to proceed and what the different documents are. You've got to have those fundamentals, or it's like you're trying to play a card game and you don't know the rules of the card game. You're playing card games with all these sharks and you don't know all the rules. You know some of the rules, but they know all the rules. You're going to lose every time. They're going to smoke you. And that's where most of you people are. You don't have the rules down there. Here's the powerful thing, though. Even though these attorneys have had $250,000 educations and 30 years of advanced training on you real life by working, once you learn what they learn, and you're probably going to learn it through jurisdictionary better than they actually know it, okay, believe it or not. You're going to learn more from that jurisdictionary course than what the average lawyer knows. Now, here's the power of this. Once you have these skills down, you can do things that attorney A won't do, and B, he can't do. So now you're more powerful than that attorney because you can do things that he can and won't do. You have no limitations. You don't have to worry about that judge that you're before. I didn't worry about the judge in that hearing I was at. I talked to him how I wanted to talk to him. That attorney, he's on eggshells. He's walking on eggshells in front of that judge, because he might see that judge for the next 10, 20 years of his career. And if he pisses that judge off, that judge could snatch that bar card away from him through sanctions and different stuff. So that attorney, that's another reason why we tell you not to use attorneys and move your own case. Because that attorney at a certain point, he won't do something that could help you if it's going to hurt the municipality, or he knows the judge is going to look down upon it. Okay? This is why you've got to learn this stuff yourself. And it's not easy to do, okay? But the thing is, it's not that I think I could teach this to anyone, Brandon. I don't think there's not too many people I couldn't teach this to. No, it's just a matter of will.
Yeah, it's not as complicated as you think. The number one problem with everybody, myself included, and you'll even admit it too, Alphonse, is the amount of bullshit that you got to unload to get to the truth, because we've been programmed with so many legal gurus and crap. That is the hardest thing for people to let go. And here's the truth, folks. Every single one of us have the equivalency of a 4th grade reading education, and yet we want to go read law documents. I'm sorry, you're going to have to up your reading comprehension and your ability to focus. You can't be like a goldfish in a bowl going squirrel all the time. You actually have to have a little discipline, a little self-mastery, and a little self-control. And what you'll find is that not every court is corrupt. Not every judge is corrupt. And with that, before I forget, I want to play this little 1-minute excerpt from you yesterday, Alphonse. This is wonderful. When you don't just talk it, you actually do it. Okay, that's another level. When the wildlife and fisheries come at me, I went after them like a bull in a china closet. I did. I lost my cool with Agent Trey. I did. I really did.
I did that too.
Gary knows how worked up I was that week. I was worked up, dude. I was mad. I was angry. But at the end of the day, you're fighting for truth, justice, honor. These people are just intellectual prostitutes who fawn at the feet of mammon. Okay, that's it. They have no inner held conviction. They're just doing their job. They're everyday button pushers. That's it. Okay, let's listen to Alphonse now. This is yesterday, Alphonse's court hearing. Y'all let me know if y'all can hear this.
It's a little low.
Listen, you don't have personal jurisdiction. There's no service of process in this matter. There's no subject matter jurisdiction. There's no complaint filed, and he's got no standing whatsoever. There's no in rem jurisdiction because they have no ownership or interest in the property. You can only bring an in rem action when you have ownership or interest in the property. You can't have an in rem action without ownership or interest. Is there somebody from Aspen Township here to testify that they have ownership or interest in my property? Because Mr. Pierce has no standing. He's got, for Rule 602, he's got no personal knowledge of anything. He could be here to testify. He don't know anything. He's got no personal knowledge. He's going by all third-hand, whatever somebody tells him. Is somebody here from Township going to ask him to testify?
And I like that. I like that.
Crickets here for about 30 seconds. Wasn't there? There was crickets.
I'm going to keep letting it play, but I just want to make a point while we're here, right? Because this goes back to the foundational foundations that we're talking about. Okay, so Joe Blow doesn't just get to make a claim against you, and there's nobody out there that has, for civil matter, some type of ownership or interest or some type of valid claim for redress of grievances. Okay, that's it. So they're doing this quasi-judicial administrative move here, and nobody there has standing. And what is standing? The ability to sue.
Right. Here's what that was about too. Here's what they do with you with these this local tax issue. So like me and Brandon were talking about, they never gave me service of process, so they never have personal jurisdiction in the matter. Okay. The municipal claim they file is not a complaint. It's not a civil complaint, and it's not a criminal complaint. So it's not a complaint. Without a complaint before that court has no subject matter jurisdiction. Right there, that court can't hear any matter. I don't care if it's administrative or whatever it is, that court can't hear any matter. But they try and be slick with this administrative law. So here's what they do through statute. They claim that they only need in rem jurisdiction, which means it's an action against your property, an in rem action. It's like saying it's an action against your house, okay? They're bringing the action against your property and your house. They're saying it's an in rem action. Well, when you go read American jurisprudence, and I read tons of stuff on in rem in American jurisprudence, and it's clear as day. Here's the only way a court gets in rem jurisdiction over property. If they seize the property in the commission of a crime. So if it's a gun that was used to kill somebody, they seize the gun to be used for evidence. The court has in rem jurisdiction over the property, okay? They don't have in rem jurisdiction over my property. Doesn't matter whether it's registered with the county or not. They don't get in rem jurisdiction of it. So the township moves this in rem action against you. But when you read American jurisprudence and you read these ton of court cases I read, you need to have ownership and interest in the property before you can bring the in rem action. So the attorney that filed this crap against me, he don't have ownership or interest. And the township he's claiming he's representing, they don't have ownership or interest. He had no legal authority whatsoever to file an in rem action against me. And that's what that exchange was with that judge. I'm trying to say, you don't have personal jurisdiction. There's no service of process. You don't have subject matter jurisdiction because there's no complaint before this court. Plus, here's another beautiful thing. And Brandon was talking about the full faith and credit clause. There's a great citing from a Pennsylvania court cases, then they just fall one into the other. And it states, when a cause of action is created by a statute, that's every traffic citation, that's every violation, that's every local tax thing. If a cause of action was created by a statute, it states there must be a party with standing in the matter. And it goes on to define that standing means someone that's been directly affected, not sort of affected or might be affected, directly affected by the matter. Because without standing, that's a judicial prerequisite. That court can't hear that case. So in this little exchange you're hearing, the township doesn't have standing, and the attorney doesn't have standing because they have no ownership or interest in the property. They're done at that point. And the reason for this hearing was that Rule 1037A that Brandon read earlier. They didn't want to serve, that clerk would not serve that rule to the township. I had to kick and scream to get this hearing, to get it on the record that, hey, Mr. Judge, your clerk evidently don't know what she's doing. I'm going to need you to serve this rule to the township. And here's what the judge said about the clerk. Well, she didn't really understand what it was. Wait a minute. So she'll send the sheriff out to somebody's house by signing a writ of Sir Quasi to steal their property from them, but she don't know what this precipice to serve the rule means. Wait a minute. Then she's not properly trained. She shouldn't be a clerk, okay? And let me get this straight. She works in a courthouse with all these judges, okay? She couldn't take my filing, which is all, I didn't make it up. It's not something I pulled out of my rear end. It's actually a thing. It's a precipice for them to file a complaint. She couldn't take it to a judge and say, hey, Mr. Judge, what do I have to do here? Because Brandon read it. He understood it. I read it. I understood it. The clerk of the court, who they're all attorneys, they're all former attorneys, most of them. You mean she didn't understand that? So that's what this hearing was about, was basically just putting this court on notice, this quasi-judicial court, that, hey, I got your game down. You don't have jurisdiction to be doing anything in this matter. And that's what that was about.
Well, let's finish this up and see how it ends, because it's pretty powerful how you end right here, Alphonse. I like it. I like it. Just state the facts. They're sitting now. I want to give y'all pause. The pause here is Alphonse asked a question. How did the court gain in rem jurisdiction in his property when he has exclusive ownership? They're sitting there. Okay.
It's awkward. It's awkward.
Can the court explain to me how you have in rem jurisdiction on my property? And it's like crickets. Chirp, 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 chirp. Okay.
I want to know how this court claims they had jurisdiction to even initiate this matter. Where did you get in rem jurisdiction of my property? Can someone please explain that to me?
Chirp, chirp,
chirp. Mr. Pierce explained it.
All right, hold on. I just want everybody to hear what the judge said. He's asking the attorney now if he wants to provide any more witness testimony or anything else. Listen, guys, this attorney has no ability to testify to any matter whatsoever. And Alphonse deals with it very succinctly. It's an objectable matter in any court because the counsel cannot testify. He is a third-party witness. He has no firsthand personal knowledge. He's little more than a little circle jerky jockey. That's it. That's all he is. And that's all we need to treat him like, because there's no membership organization or group of people who have caused more harm to this United States of America than these phony baloney bar members and their continued destruction of the English language and hiding behind their obfuscation and all their little statutes and everything else, where they paint everything in real pretty like, and then they go defraud the people so they can sit around and sit in fat houses and everything else with no conscience because they have no internal conscience of God.
What's that Bible citation? Woe unto you lawyers.
Woe unto you lawyers. That's right. Because they have no conscience. You almost have to be a sociopath to be one.
I don't know that I have anything, because again, don't know where I'm supposed to go with this. I'll standard legal process. Did I interrupt you, sir? Sir, you shouldn't even be here.
So what happened was, like Brandon said, the judge went back to the attorney and asked him, did he have any more to say? And he said, I don't really know why I'm here. Then he said something like, I don't really know why I'm here. And I said, sir, follow standard legal process. That's what you and I are entitled to. Standard legal process. Sue me, okay? And he turned around and said to me, sir, did I interrupt you? I said, sir, you shouldn't even be here. You have no authority to even be speaking right now, let alone to be here. And
well, why are we
ended right there?
Why are we going to give them opportunity to put anything in the record when they have no? They listen, guys. They have no business speaking, none. Okay, there's no client that they're representing that has a living, breathing, sentient that actually has claim or interest or ownership in anything that's going on in there. They're completely hiding behind a fictitious plaintiff, moving a fictitious complaint against somebody. That's it. That's really it's a facade. It's a facade. And so everybody in America takes these quasi-judicial courts and applies it to all courts. And that's not the case. There's bad judges. We got a bad judge right here at the Middle District of Louisiana. We're going to have to do injunctive relief against her. And guess what we're going to have to do with all our cases? We're probably going to have to long arm our cases after we do this. Why? Because we're filing injunctive relief against her. Or we'll just have to recuse her from the cases. But make no mistake, the battle's starting. And the lines are drawn in the sand. There's no giving up. You're standing for principles of truth and what's right. Okay, that's it. That's all you're doing. Either abide by the rules that have been set forth, or just simply throw them out the window. But these rules, the more you dig into them, except for the administrative courts, the administrative courts are there to trick you, no doubt about it. But
now, that hearing that you just heard, here's what that hearing does. Listen, I've told that judge right out, you don't have jurisdiction in this matter. And guess what? He knows you don't have jurisdiction. He proceeds to act without that jurisdiction. See that immunity judges have? Bye-bye. As soon as he acts outside of his responsibilities and duties, he can't act without jurisdiction. He knows you don't have jurisdiction. I'm sitting there asking him, how did this court get jurisdiction? Is there anybody from Aston Township coming up here to testify that they have in rem jurisdiction over my property? And there's crickets, because they know that's the elephant in the room I just pointed out. Because guess what? Most people, Brandon, when they get these complaints, they miss the in rem part up there in the heading of the in rem, or most don't understand really what that means. That means an action against your property. Well, guess what?